My brother and partner of 12 years was negotiating to sell our company without telling me. I found out because a lawyer sent the contract to the wrong email. What happened when I confronted him was the hardest thing of our history as brothers and as partners. There are things that carry your name in a way that is not only legal, that are not only the percentage of participation in an articles of incorporation, that are years of decisions made together, of nights solving problems that seemed unsolvable, of conversations with clients where both of you represented something neither of you had built completely alone. Grupo Montoya carried my name and my brother's in the most literal sense and in the deepest sense. Our father had founded it. He had left it to both of us. 12 years directing it together. And my brother had spent 6 months negotiating its sale with an investment fund without telling me anything. I found out because of a typo by a legal assistant who sent the contract draft to the wrong email. My name is Rodrigo. I am 50 years old. I am the general director of Grupo Montoya, a manufacturing and distribution company for automotive industry components that our father founded 32 years ago, and that since his death 12 years ago, my brother Ernesto and I have directed as partners. Ernesto is 47 years old. He is the director of operations. We have spent 12 years in this dynamic I would have described as functional and honest, with the normal tensions of two brothers who are also partners, with the differences in vision that are inevitable when two people share responsibility of that magnitude, but with the foundation that big decisions we made together. That was what I thought. The email arrived on a Tuesday at 10 in the morning. The subject line said Draft Purchase and Sale Agreement Grupo Montoya for final review. The sender was a law firm I did not recognize. I opened the email thinking it was an obvious mistake intended for another client. The name in the document left no doubt that it was not a destination error in that sense. It was my company. The buyer was an investment fund called Grupo Inversions Nexo. The structure was a purchase and sale of 100% of the shares. The seller listed was Ernesto Montoya, representing the shareholders. My name did not appear as seller. It appeared in a third-party representation section that would require my signature for the transaction to be valid. I read the entire draft, 37 pages. I read it twice, not because I did not understand what it said on the first reading, but because the second reading was the process of processing what the first had found. The purchase price was 240 million pesos. The structure included an 18-month transition period where Ernesto would remain as director of operations with the new owner. I did not appear in any function during that transition period. The closing was contemplated for 3 months after signing. The negotiations had been going on for 6 months, according to what could be inferred from the dates of the annexes. I stayed in my office with that document on the screen for a time I cannot precisely measure. It was not immediate anger. It was something more like dissociation. The feeling of someone who reads something about their own life and reads it from the outside as if it were happening to someone else. Then the anger arrived. I called our corporate attorney. Her name was Patricia, and she had spent 8 years handling the legal matters of Grupo Montoya. I sent her the document without saying anything else. I called her 30 seconds later. I asked whether she had seen the email. She told me yes. I asked her what I was reading meant. She told me to give her 15 minutes to read it completely, and she would call me back. Patricia's call arrived 20 minutes later. She told me 3 things. The first, that what the document described was a purchase and sale negotiation for the entirety of the company that, according to the annexes, had been in process for at least 6 months. The second, that the structure required my explicit consent to be valid because I was a shareholder with equal participation to Ernesto's. That without my signature, it could not close. The third, that Ernesto had been acting as if he had authority to negotiate on behalf of both of us without having it, and that had legal implications we needed to discuss before I spoke with Ernesto. I asked when she could meet. She told me that afternoon. The meeting with Patricia lasted 2 hours. What she explained in those 2 hours was what I needed to know before facing Ernesto. The contract that had arrived required my signature. Without it, the transaction could not close. That put me in a position of power in the process, even though Ernesto had not calculated it that way. The negotiations Ernesto had conducted without my knowledge potentially violated the partnership agreement we had. That agreement established that any negotiation for the sale of the company or shareholder participations required notification and consent of both partners. Patricia recommended that before talking to Ernesto, I decide what I wanted. Not what I wanted to say to him, what I wanted to result from the situation. That question took me longer than I expected. What did I want to result? I did not know immediately. There were several possibilities. I could reject the sale completely. That was my right. Without my signature, there was no transaction. I could demand to be included in the negotiations from that point, with all the information that had already occurred without me. I could use the situation to force a conversation about the partnership that had been necessary for some time, but that neither of us had had. And I could, if what I found in the conversation with Ernesto justified it, consider whether there were conditions under which the sale could also make sense for me. Those four possibilities were not mutually exclusive, but they required first listening to what Ernesto had to say. I called Ernesto that afternoon. I told him I needed to see him. That night, at the company, he asked whether something was wrong. I told him yes, that I would explain when we met. Ernesto arrived at the company at 8 that night. I was in the boardroom with the contract draft printed on the table. When he came in and saw his expression, told me everything I needed to know before he said a word. It was not surprise. It was the recognition of someone who knows exactly what they are looking at on that table and who understands that the conversation they had postponed for 6 months could no longer be postponed. What Ernesto told me over the following hour and a half was the most honest thing he had told me in 12 years of partnership. He told me he had spent 3 years feeling he wanted to leave the company, that he had reached a point where directing operations exhausted him in a way that was no longer sustainable. That he had thought many times about telling me what he felt, that every time he had been close to doing it, he had found a reason not to, that at some point he had started exploring sale options as a way to leave that did not require having that conversation with me, that he knew what he had done was wrong, that he had rationalized that if he found a buyer and presented a concrete offer, it would be easier to convince me than if he arrived with an abstract idea of wanting to leave. I asked him whether at any point he had thought about what that logic did to me, about the fact that presenting me with a contract in hand from a 6-month negotiation put me in a position where the pressure was different from a conversation between equals. He told me yes, that he had thought about it, that he had chosen to do it anyway, because he was afraid of what I would say if he told me he wanted to leave. I asked him what he thought I would say. He told me he thought I would convince him to stay. That I was good at that, at finding the right arguments that made things seem manageable when they were not, and that this time he did not want to be convinced, that he wanted to leave. That answer was the most important of the entire conversation, not because it hurt less than the previous ones, but because it was the most honest about what had produced the situation. Ernesto had not negotiated the sale because he wanted to harm me. He had negotiated it because he was afraid that if he told me directly, I would convince him not to do what he needed to do. That logic was wrong in its mechanism, and it had something true in its description of our dynamic that I needed to hear. I told Ernesto I needed several days before responding to what he had told me, that the sale process would stop while I processed, that if I decided the sale could also make sense for me, there would be a different conversation, that if I decided there were no conditions under which I wanted to sell, I would tell him directly, and we would talk about how Ernesto could exit the partnership another way. Ernesto said that was fair. The days that followed were the hardest to process of the 12 years we had been directing the company together. Not because the sale itself was unthinkable, but because what had come out in that conversation was more important than the sale. The description Ernesto had given of our dynamic, the fact that he had reached a point of exhaustion I had not seen or had preferred not to see, the fact that in 12 years I had been so good at finding the arguments that made everything seem manageable that my brother had reached the point of not being able to tell me he could not continue without first building an exit that did not require going through me. That said something about both of us, not only about Ernesto. I decided that if Ernesto wanted to sell, I wanted to participate in that process, not as an obstacle, as a co-seller with the same rights and information he had had during 6 months. I proposed to Grupo Inversions Nexo to reopen negotiations with both brothers at the table. Nexo accepted. The process restarted, with Patricia representing both of our interests. With all the information on the table, with my questions and my conditions having the same weight as Ernesto's. 3 months later, we reached a sale agreement that was different from the original draft in several points that mattered to me, including an employment continuity clause for the employees I was most concerned about, including a transition period where I also participated instead of being left out as in the original draft, including an adjusted price that reflected the real value of the company with complete information from both parties. Grupo Montoya was sold. It no longer exists as an independent family company. That is something I'm still processing. The relationship with Ernesto exists, not with the same dynamic it had before that night in the boardroom, with a different dynamic that is still taking shape. There are conversations we are having now that we did not have in 12 years, about what each of us needed and did not say, about the dynamics we had built without naming them. Those conversations are difficult. They're also the most honest we have had. What I want you to take from this story has parts for very different people. For those who have partnerships with family members, the dynamics you build as brothers or as family within a business relationship are real and have consequences for how business decisions are made. Naming them does not destroy the partnership. Not naming them creates the space where someone builds a secret exit, because talking directly seems harder than negotiating with an investment fund for 6 months. For those in Ernesto's position, if you want to exit a partnership with someone you know and love, the direct conversation, even when difficult, is always better than secret negotiation. Not only ethically, practically, because in a well-structured partnership, you cannot close without the other person anyway. The conversation you fear ends up happening. The difference is that if you have it first, you have more options. If you have it after the draft arrived at the wrong email, you have fewer. And for everyone, partnership agreements that clearly establish processes for the sale of participations or the complete business are the most important document that exists in any partnership. Not to distrust, so that when someone wants to leave the conversation, has a structure that protects both parties. If this story resonated with you, comment. Do you believe partnerships between family members have specific dynamics that make it harder to have certain difficult business conversations, or do you believe the family relationship should facilitate those conversations? Like if you believe partnership agreements should be reviewed periodically by both parties to verify they still correspond to what each wants. Subscribe for more real stories. Share with someone who has a partnership with a family member or friend and who might benefit from this story. Reflection to take with you. The conversations we postpone with the closest people do not disappear. They accumulate until they find an exit we did not choose. Sometimes that exit is a contract draft in the wrong email. The discomfort of direct conversation is almost always less than the consequences of the conversation that arrives on its own when it can no longer be postponed.